4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
I'd like to welcome to the studio, welcome to the microphone, Andrew Bell from Bell and Senior Lawyers.
Thanks, Colin. Thanks for having me back for our second live episode.
Yes, it was a great little episode last week, and we are going to get into that in just a moment. It is our fundraising event 2026 this week. This is one of the reasons why you donate to your favourite radio station, 4CRB, and that is because where else do you get free legal advice, all those wonderful shows that we put together on a weekly basis that provide you free advice, free access to experts, and this is one this morning. It is a talkback program. We do invite you to call in right now, 0755 208888, and if you'd like to ask a legal question of Andrew, you're more than welcome. We've got a wonderful topic today. We're going to be talking about EPOAs, but first of all, we had a question from last week that you did a little bit of research on. You've got the answers.
Indeed I did. So an EPOA, or Enduring Power of Attorney. Last week Patricia had a question about one of these. Her question was if she had a New South Wales Enduring Power of Attorney and it was signed in Queensland, would that be valid? And she said that the banks had knocked her back on that. Our position, I've done some research and spoken to some other lawyers about it. In Australia, lawyers are nationally recognised, so I've been able to appear before the Supreme Court and the ACT with my Queensland practising certificate. The New South Wales law says that a lawyer, a barrister or a solicitor can sign off on the EPOA, be the witness, etc., as long as the appropriate rules are followed. So it should be valid on that basis. And in Australia, any enduring power of attorney, or EPOA, as we'll call them throughout this show, is valid in every state of Australia. So if you had one signed in New South Wales and you moved to Queensland, you can rely on it in Queensland. She said that the bank wasn't letting her do it, so we'd actually need to have a look at the document to make sure it was signed properly. And if someone came to me and asked to witness a New South Wales one, I'd probably put it on the Queensland form. So I think she needs to get some more advice to actually check it out. And the other thing with enduring powers of attorney is the banks will often want to see the original rather than a certified copy. So that may have been the issue that they had there as well.
Yes, it sounds like there's many layers to the onion. We might start off with the very first layer. What is an EPOA?
So an enduring power of attorney is a legal document that allows you to appoint someone that you trust, or multiple people that you trust, as what we call your attorney. So they're not a lawyer like an American attorney. They're actually someone who can represent you to make your financial, legal, and personal health decisions. And you may decide that one person you want to do your financial decisions, and you might want a number of family members to make your health or personal decisions. What they mean by personal decisions is not just if you're in the hospital and what operation should be done, but also, do you need a wheelchair? Do you need help with Centrelink? Do you need help with living in an assisted care facility? Your attorney can help you do all of those things. And the next question would then be, well, when does your EPOA kick in? So for financial matters, you can decide it's immediate or on a particular written event. So maybe you're going away caravanning around Australia for 6 months and you want someone to be able to pay your bills. You could actually appoint your attorney in writing and say for the next 6 months, I'd like that attorney to be able to manage my financial affairs at home. For your health and personal matters, it's once you've lost capacity.
So and that's a good point. So you can voluntarily enact it for financial reasons. I'm going overseas, please pay my bills and look after my rates and do all of those sort of things. But when it comes to medical, this word of capacity does come up. What is it?
So capacity is both a medical and a legal concept, but essentially it means you're unable to make decisions for yourself. The typical example used is someone has dementia and they're not quite sure of where they are or what the implications of the decision they're making are. But it also may be that you're in hospital and you're in a coma and you can't do things. It's being not able to make the decisions that you need to make in a proper way. And this is where an enduring power of attorney can become in very handy. It means that if something happens to you and you're still alive and you can't make those decisions, that you've already set out how you want your affairs to be managed. Last week we talked about after you die, how you want your family to receive things and how your estate to be managed, which was your will. And your enduring power of attorney is what happens when you're still alive. Once you've lost that capacity, though, you don't have the ability to appoint a power of attorney or appoint who wants to make those decisions for you. So the key is you need to do it before these unexpected life events happen rather than afterwards.
And look, that's a very good point, and I think we'll go into what happens if you don't have one and you are incapacitated in a moment, and I think that will illustrate the point. But we often talk about this in our financial programs, in any number of our programs, our medical programs. This is about having a plan. This is about thinking ahead. I don't know what's in my future. I don't know if I'm going to have an accident. I don't know if I'm going to fall ill suddenly and I'm going to be in a coma, as you used it as an example. Dementia is another issue that comes up when we talk about this issue. And having a plan means that your wishes, and you have nominated the right person, the person that you feel comfortable with making decisions on your behalf, is in your future.
Absolutely. And even just being able to pick the right person is very important. And we all know that some people are great with money and some people are great with care, and they're not necessarily the same person. You may love your husband but say, this isn't the person who should be managing my finances. However, if you don't have any of your wishes recorded and you're unable to speak for yourself because of those capacity issues, then in QCAT or somewhere else, the person that you think is wrong may actually end up managing your affairs.
Okay, so let's move on to that final question, or the final component, I suppose, and it's not really the end. What happens if you do lose capacity? A doctor says, no, you cannot look after your own affairs for whatever reason that may be. Who looks after you? Who makes the decisions on your behalf if you don't have an EPOA?
So if you don't have an EPOA in place, then until someone goes to QCAT, which is the Civil and Administrative Tribunal, it's the all-in-one tribunal for Queensland, and asks for an order and proves that you don't have capacity, and someone steps up and says, I want to do this, then by default it would go to someone called the Public Trustee, which is a Queensland organisation. They're not your family. They don't know you. They'll try and make the best decisions on your behalf. Otherwise, though, until QCAT makes that decision, you're in a bit of a legal grey area around who can access the money in your account, who can actually sign off on these various healthcare decisions or living arrangements or anything. So families try and do the best they can, but sometimes that can take quite a long time.
And look, I would imagine that's exactly the point, Andrew, that when you have capacity and you're making decisions for yourself, and let's just make it simple, I need glasses, so you go to the optometrist, you get glasses. When you don't have capacity and you need glasses, you're using the words the public trustee, you're using the words of going down the road of a process. It might be quite some time before you get that pair of glasses or the medical help that you actually require, because the decision is a long process.
Absolutely. But an EPOA, typically the ones that we draft, two doctors need to sign off to say that you've lost capacity, and then that EPOA kicks in immediately.
And your wishes, because you've planned this well beforehand, and that's the bit that I feel is amazing about this discussion. Again, it's about having a plan for your future. You nominated the people that you wanted to be in charge of your finances, your medical decisions, and so forth, so therefore your wishes are adhered to.
Absolutely, and you can review them and change them while you've got capacity, and it's our recommendation every couple of years that you still pull it out and check and make sure that the people that you said that you trusted to look after your affairs are still those people that you still want to do that going forward.
So, Andrew, can you appoint more than one person, and what would you recommend?
Absolutely, you can. Now, obviously, it depends on the people and the situations. However, typically, if we have a husband and wife come in to do an EPOA, normally we'd have the other one as the primary attorney. However, people do get old and it can become overwhelming. So it is the possibility to appoint other people. either children, lawyers, other trusted people who are prepared to help. And they can either be appointed as alternatives. So if the husband says, oh, look, I really can't look after this at the moment, I've got enough on, and I'm not sure I'm doing the right thing, that they can appoint those alternative attorneys, or they can do it in conjunction with them.
So there can be a hierarchy, or it can be a collaborative decision.
Both. You can either say that they must jointly make decisions, or they can individually make decisions, and you can determine that as part of how you set things up. But as I said, normally the standard ones that we would draft would say the partner makes the decision. Otherwise, there may be two children, and they need to make those decisions jointly. Or if the husband requires help, then he can engage those alternative attorneys.
So, Andrew, just when we were talking about losing capacity before, once a power of attorney is enacted, are there limits on what an attorney can do?
Absolutely. So for financial matters, what they can do for you is they can access your bank accounts, they can pay your bills and expenses, they can buy and sell and manage property, they can sue people on your behalf. But there are things that they can't do. So they can't make or change your will, for example. Mm-hmm. They can't make decisions after you die. They must make decisions in your best interests, which is very important. We do get very worried about elder abuse, and some of the questions, if you were going to get an EPOA, a lawyer might ask, is to make sure that you understand what's going on and you're doing it independently. And if you request, you can make sure that they actually have to justify the decisions they've made. You could say every expense over $1,000 needs to be sent to me every 3 months. So then there's at least a paper trail so you can understand what's going on.
So that leads me to my next question is, what protections exist to prevent misuse or financial abuse?
It's mostly that reporting angle. And if people think that it's being abused, they can go to QCAT and ask for the EPOA to be overturned. But I think the majority of people, it's about getting the right person that you trust and making sure that people are able to see what's going on financially to make sure that they're held accountable.
I was going to say we might get a message from one of our sponsors, and then we'll invite you to call in. It is a talkback program. 0755 208888 is the number if you'd like to call in and ask a legal question of Andrew from Andrew Bell's. I'm getting tongue-tied already. Bell and Senior Lawyers, and it would be fantastic to hear from you this morning. 0755 208888.
Wills, probate, powers of attorney or property matters. Legal issues don't need to feel overwhelming. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 5532 3133 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple.
All right, we're back with Legal Matters, and this is your opportunity to ask a question of Andrew Bell from Bell Senior Lawyers, and we're talking about EPOAs this morning.
Yeah, we are, Andrew, and given the fact that we live on the Queensland-New South Wales border here, what are the differences between a power of attorney in Queensland as opposed to a power of attorney in New South Wales?
So in Queensland, as I said, they cover both health and financial matters, and they are nationally recognised. In New South Wales, a power of attorney is only, an enduring power of attorney is only for financial matters. However, you can have a guardianship document, an enduring guardian, which covers those personal and health matters. There's also some legal nuances around who can sign them off, but essentially the same rules apply. The attorney or guardian that you appoint can look after your affairs depending on whether they're for financial or health reasons, and if you sign it off, you must have capacity. In New South Wales, it must be a lawyer that signs it off, whereas in Queensland you can get a JP to sign it off, but they need to make sure that you fully understand the ramifications of what you're signing before you sign it for that to be a validly enacted document.
And if people were to, say, live in New South Wales, make a EPOA, make a power of attorney in New South Wales and then move to Queensland, would you recommend redoing your power of attorney in Queensland if you now reside there?
No, I don't think I would. I think because, as I said, because they're nationally recognised and they get very similar powers, as long as they appear valid, I wouldn't change it immediately. Every 5 years or so, I'd recommend that you bring them out. There may be changes to legislation. There may be changes to how they apply and who they apply to. But at the moment, if you had a valid New South Wales EPOA and lived in Queensland, I don't think I would get it refreshed.
And that's probably a good question there. So you mentioned 5 years. Just like anything in life, it should be reviewed at a set period just to make sure. And it's a due diligence thing, for want of a better term. If you had an EPOA from 20 years ago, it may very well be that someone looks at it and goes, well, how is this relevant today? Is that fair?
Absolutely. And we redid 2 last week that appeared to be 30 years old from Queensland. The language is very different. The form's very different. If you wanted to take it to a bank, I'm sure they would not enact it straight away and would want to seek their own advice on an older document compared to something that's on the prescribed form that's using the modern language, that it's very clear that it applies in all the situations that people are using EPOAs in today.
And what age should someone take out a EPOA?
Well, an EPOA is valid from anyone who's over 18 years old. They act indefinitely. So there's no reason to delay getting an EPOA. The more assets you've got, the more likely you think that it is that you may be in decline. We have people going overseas doing extreme sports type things who are worried that they might injure themselves and need someone to make decisions on the way back. So I've done EPOAs from 18-year-olds to 80-year-olds.
And it is a good point. You're always 10 foot tall and bulletproof at 18 years of age, but the point being is, do you want clear lines of decision making? So if you're injured, if you are in a coma, if something's happened to you where you're not compos mentis and can make decisions for yourself, you've got the person that you wanted making the decisions for you.
We recently had an expectant mum, the same thing. She wanted to make sure the husband could make decisions for her when she's giving birth if she's not able to make those decisions. So having that in writing, because automatically your spouse doesn't necessarily have the power to make health decisions for you.
And that's a good point to make, because people will jump to that conclusion. They're my husband, they're my partner, they should be able to make decisions on my behalf, pay my bills, do all of those things.
So the hospitals do have powers in place. There's also something similar to an EPOA called an Advanced Health Directive. However, they will try and work out things, and if they can't find people quickly and a decision needs to be made quickly, then they'll delegate that to a senior person in the hospital to make those decisions if they can't. That may not align religiously or ethically to the way that you want, or culturally to the way that you want to be treated. They'll try and do their best. However, if they don't know you, there's limits on how much they can do.
So, Andrew, another good point. Once you've made your EPOA, where should you store it?
Okay, so the EPOAs, like wills, are some of the few documents where an original is required. So an original wet ink signature, as they call it, you actually have to come to the office, you have to physically actually sign it. Our recommendation, like the wills last week, where I was saying, we'll give you a copy of the will, put a fridge magnet on the fridge telling people where the will is, same with the EPOA. Most people will accept a certified copy of an EPOA, but not everybody. But if that original disappears, then the power behind that original is lost. So we would normally recommend, if you went to a solicitor's firm, that the solicitor keep it in their safe. They give you a scanned copy of it. They give you a certified copy of it so you can keep it at home if you need to give it to someone or share it with someone. But if anyone actually needs to double check that original, then they can get the solicitor.
7 minutes left in the program. We'd like to invite you right now to call on in. If you like to ask a question of Andrew Bell from Bell and Senior Lawyers, 0755 208888 is the number. Call now and you'll get straight through and your question will be answered live on air.
So, Andrew, what are some of the biggest mistakes people make when they are setting up an EPOA?
It may sound biased, but I think a lot of people trying to do it themselves without experience of the legal conditions and then potentially not having them witnessed properly. So as it's very important that it's very clear what what we call the principal is the person signing the EPOA, what the principal's wishes were. Then next, it's very important to understand when it kicks in, when it becomes available, and very clearly identifies the parties. And then they need to demonstrate some sort of proof that they actually understood what they were signing when they signed it. If you can't do any of those things, then it's liable to be challenged in the future. So doing it yourself and not getting it signed properly are probably the biggest things to look out for. Or the other thing is not quite understanding what their true intentions are. You've got to actually have some time to think about what are the guidelines that you want your attorney to do. Do you want to be living in dignity? Do you want to live in your own home? What are the guidelines that you want to give your attorney as the little checkbox?
And are they conversations that families should be having around this when people are looking to appoint their power of attorneys?
Absolutely. I think blindly appointing people is not a good idea. Just because you trust your son and you think that they'd make a great attorney, surprising them when in the future that they're now your attorney and they need to make all these decisions, they may say, Mum, I can't make those decisions for you. I don't think I'm the right person. I think you should have picked someone else. Or I want to make these decisions, but I don't even know how to do that. I don't have the right skills, or I'm not sure what you want. And so we recommend that people come in with the proposed attorneys to meet with us if they're going to sign an EPOA. So that everyone involved in the process understands what their role would be. Also, people, if they're aware that they're nominated as an attorney, can then be involved in any future decisions. We find it difficult when people move overseas who are nominated as an attorney, and it may be found best that that person is an attorney, but they're not necessarily the sole attorney to make decisions, but they need to be involved. They may protect you against some elder abuse if you pick someone you don't know as well as your Gold Coast attorney, but they need to share the decision-making with the person who's overseas, because it might be very difficult for the person in New Zealand to get to the bank or sign things off or do things in a timely manner.
Yeah, it's difficult enough when you are local to that person, let alone if you know you're interstate or overseas. And Andrew, what happens if someone was to have a power of attorney in place, they lose capacity, and then the attorney decides that they don't want to do it or they can't do it? What happens in that instance?
Well, again, if we had alternative attorneys, it could go to the next one. Unfortunately, otherwise, it probably goes to the body I talked about before, the Queensland trustee.
Well, we've got our first caller and probably our last caller at the end of the program. It's a very good morning to Caroline. Caroline, ask your question of Andrew.
Oh, hello, Andrew.
Good morning.
Could you please explain a health directive?
Okay, so an advanced health directive, or an AHD, is similar to a power of attorney. It gets logged with Queensland Health. It needs to be signed off with your doctor, so you can talk about treatment options, etc. And it has similar effects to the health component of a power of attorney. If you like, we can talk about these on a future episode, and I can go through everything that's required to set one up. An advanced health directive, like an enduring power of attorney, also kicks in when you lose capacity. So, but it's more medically focused on the medicos being able to look at it directly and make the decisions, maybe in consultation with your nominated person, or maybe just following your written instructions directly. They're most commonly used for do not resuscitate type orders, where if you've decided you don't want people to go to heroic lengths to resuscitate you, if you have an advanced health directive that nominates that, it's very helpful for the healthcare workers to look at.
Does that answer your question, Caroline?
Yeah, that's answered it. Okay, yeah. All right, thank you very much for that.
Thank you very much for your call. All right, well, we have a minute left in the program, and maybe it's probably a good point to just highlight the difference between those two documents. So one can handle your finances as well as your medical decisions and nominate someone to look after you, and the other one is only health related. Is that?
That's correct. So the enduring power of attorney has a finance component, it has a health and personal matters component. The Advanced Health Directive only has the health component to it and requires different procedures to enact.
Perfect. Well, we're at the end of the program. It goes very, very quickly when you've got an interesting topic to explore, doesn't it? Thank you very much for your time again this morning, Andrew Bell from Bell and Senior Lawyers.
Thank you, Colin.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.